How does intellectual property enter the public domain? Have you ever wondered what happens to creative works and inventions once their legal protections run out? Let's take a closer look at how intellectual property transitions into the public domain. The public domain is a space where creative works, inventions, and trademarks can be used freely by anyone without needing permission or paying fees. Once something enters this domain, no one owns it anymore. For patents, which protect inventions, the typical protection lasts for 20 years from the application date. Design patents have a shorter term of 14 years. After this period, the invention can be used by anyone. However, there are situations where a patent can enter the public domain sooner. If maintenance fees are not paid, the patent can expire early. Sometimes, patent terms can be extended for up to 5 years under specific conditions, but once all options are exhausted, the patent ends and the invention becomes public domain. Now let's talk about trademarks. These protect brand identifiers like logos and slogans, but they requiring active use and defense. Unlike patents, trademarks do not have a fixed expiration date. They can enter the public domain if the owner abandons them or fails to enforce their rights. A trademark can also become generic, meaning it is used to describe a type of product rather than a specific brand. When this happens, it loses its protection. For example, words like escalator and aspirin started as trademarks but became generic over time. In copyright law, which is a bit different from patents and trademarks, works enter the public domain mainly when the copyright term expires. This term usually lasts for the life of the author plus 70 years. For corporate works or those published before 1978, the term is typically 95 years. Once this time frame is up, the work is free for anyone to use. Copyright can also be lost if the owner does not follow renewal or registration rules, or if they decide to dedicate the work to the public domain. Some works never qualify for intellectual property protection and are automatically in the public domain. These include facts, ideas, processes, and short phrases. They lack the originality needed for protection, making them available for public use right from the start. When intellectual property enters the public domain, it allows anyone to use, reproduce, modify, or sell the previously protected work without needing permission or paying royalties. This encourages innovation and competition. For instance, once a patent expires, other companies can create generic versions of that invention. Similarly, if a trademark becomes generic or is abandoned, others can use it freely. Public domain works can be incorporated into new creations without any legal restrictions. In summary, intellectual property enters the public domain when protection terms expire, rights are abandoned, or the subject matter is not eligible for protection. Understanding these processes helps us appreciate how creativity and innovation can thrive in a shared space.